Hello YouTube, I'm Vince White. I'm an employment attorney on this channel. We answer publicly posted questions from YouTube users, getting folks the answer they need from an employment attorney. We have a question here from YouTube user John Craig 86. Quick note, we're still working on the religious accommodation series. I'm playing with how I want to do it because there's like some complex themes and tests inherent to religious accommodation cases, and I'm trying to think of ways to present it that are meaningful and generally accurate, but also deeply oversimplify the topic. And I'm having some trouble doing that, so we're working on it, workshopping it a little bit, trying to find something that works. So that is still coming, but it's not coming today as was previously advertised. YouTube user John Craig 86 asks us, a colleague of mine provided over 200 plus documents in a case of discrimination. Is that excessive? Depends, John. Depends where the case is. If that is in discovery in federal court, I would say that's light. That's the lightest I've ever heard. No, it's not the lightest I've ever heard, but it is very, very light. Like, it would not be strange to me to get 500,000 pages of documents in discovery in federal litigation. That would be somewhat commonplace in this day and age. Now, in the EEOC, 200 plus documents could be perfectly reasonable. Could also be a significant amount of disclosure, more than you generally see attached to an EEOC charge or even a rebuttal for that matter. That would be a substantial amount of documents for the EEOC or even most state agencies. Although, listen, if the documentation is useful and correct and furthers your cause, then I would urge you to consider using it and attaching it. Just, you have to make sure that it's actually serving your purpose. Sometimes repetition or overproduction can be negative for you in terms of both the finder of fact and what they are capable of in terms of their attention span, but also, and when I say finder of fact, I mean judge, arbitrator, mediator, administrative law judge, right? Any of those. Even a jury, right? Juries have limited attention spans as well. But it can also, in terms of the other side, expose you to a little bit more prying, a little bit more of an opportunity to poke holes in your argument when there's a lot of things there. There's a lot of things for them to look at, and it gives them a little more to work with sometimes, so just be aware of that. But generally, I would say that's not a crazy amount. Certainly not for federal litigation. It is a lot for an agency case, a federal or state agency case. Anyways, like, subscribe, comment down below, share the channel so it may grow. I wish you great luck, or your friend great luck. I guess it is your friend who has provided documentation. And share our channel so it may grow. Take care.